depending on the laws in that particular state, as a pedestrian, the laws still apply to you. In North Carolina, where we have the standard of contributory negligence, you would not be entitled to recover even if you were a pedestrian if you in any way contributed to your injuries or the accident. If you were in South Carolina, again, which is a comparative negligence state, you would be able to recover less your percentage of negligence as long as you were not more than 50% at fault for the accident. In North Carolina, the standards of contributory negligence differ and vary depending on the age because the law views the capability, both intellectually and emotionally, of a child differently when it comes to culpability as to an adult. If you are under the age of 7, generally in North Carolina, you are incapable of contributory negligence. So even if you are at fault, legally the standard is if you're under 7 years of age, you cannot appreciate, understand, and therefore you're not held to any standard of responsibility. If the child is within the ages of 7 and 14, it's something called a rebuttable presumption, which essentially means that you have to prove that the child knew or should have known that a dangerous condition existed and they should have been able to take appropriate precautions. Any child over the age of 14 is treated as an adult for the purposes of the law with regard to liability and contributory negligence in a pedestrian accident. There will be a number of different issues that need to be explored if you are injured by a hit-and-run driver. Number one is, can the identity be determined of the hit-and-run driver? And if not, ultimately there are usually some coverages that one can use either with their own coverage or within the household who's a resident relative to be able to pay for your medical bills. It is critical to contact an experienced personal injury attorney who can help look at the potential avenues of recovery for your injuries and medical expenses. If the insurance company contacts you, it is imperative that you neither give a statement, that you neither sign anything that is offered, and that you try to, as best as possible, not discuss any of the facts about the injury, the accident, or your medical treatment. The insurance company is calling for a reason, and their job is to either minimize the value of the claim or be able to negate it or deny it completely based on your statements and or comments about either the facts of the accident and or your injuries. It's important that you talk to an attorney and not to a representative from the insurance company. They are not on your side.